TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome back to yet another exciting episode of our talk show with the experts. మనతో ఉన్నారు మన expert Rahul Reddy garu. Rahul garu, thank you so much for being here.
Thanks for inviting, and Dave. Every week it's such a pleasure to come and share the information. Also get the feedback from the community, what's going on, what the things that I learn in TVASIA is very, very, very good for my practice too. Thanks for all.
Honor and pleasure is ours, Andy. Thank you so much. And to all our viewers, a very, very happy Valentine's Day. I hope you all have made some special plans with your special people. It could be anyone. It could be a girlfriend, boyfriend, wife, husband, and your kids, your parents. It doesn't matter, but I hope you have some plans for today and have a wonderful day. But in the meantime, Rahul garu, let's start off with this. It's been sort of a burning and a recurrent question about this non-immigrant status versus adjustment of status. Now, Rahul garu, we have many people who filed for the adjustment of status. Should they still be maintaining their non-immigrant status, or should they start using EAD? I know this has been a very, very common question, but I thought we should give a little segment to address this for a lot of people.
That's good, Andy. We have approximately maybe 500,000 people are in adjustment of status that filed in the month of October and November, just a little bit less than 500,000. So now we need to see that, do they need to maintain the H-1B though? There are two classes of people I definitely do not recommend to move to the adjustment of status. I recommend strongly that they maintain a non-immigrant status. One is, if anybody has kids who are 15 years or older, and they filed the adjustment of status in October and November, and their priority date, the final action date is not current, they should not move to the adjustment of status. They should maintain the non-immigrant status until the final action date becomes current. Once the final action date becomes current, the kid gets locked in, the age gets locked in, then they can take the decision. This is one kind of people that I definitely don't. The second kind of people that should not move to the adjustment of status is, do not move to the adjustment of status until your underlying I-140 is approved.
Okay.
Second point. Third point is, they should not move to the EAD, even if they get it, until 180 days after they file the adjustment of status. These are the three conditions that's a must for everybody, that they should not move to the adjustment of status. Now, having said that, there might be some exceptions. They may have some underlying problems for the H-1B, for the non-immigrant H-4 visa. They may consider maintaining the non-immigrant status instead of moving to the adjustment of status. They should evaluate it and check with their lawyer to see if it's worth for them to move to the adjustment of status. Now, for the rest of all the people, which I would say that approximately 90% of them fall into this particular category though, I'm not going to tell them to do or not to do, but I will tell them that if I were in the adjustment of status and all the other conditions are not applicable, the ones that I explained though, if I were the people, I will not maintain the non-immigrant status. I don't want to. I mean, if you're flying from LA to New York, why do you have to buy two tickets? One ticket is enough. That's the way I believe it. There are a lot of Google stories and information that's there on the website that says it's dangerous to be in the adjustment of status. You should always maintain the non-immigrant status. Yeah, I mean, that's good for lawyers because we make money when you buy two tickets. One, you're buying a ticket in adjustment of status. One, you're buying a ticket in the H-1B or H-4. Yeah, that's good for immigration lawyers. So that's the reason that I'm telling that if I were the people, I will not maintain the non-immigrant status though. Very rare exceptions will be there where they may have some trouble if they do adjustment of, if they maintain but mostly it will be very beneficial if they move to the adjustment of status. That's my personal opinion. I'm not going to tell them what to do. This is my personal guidance. And I want to also cautiously advise people that it doesn't look like the adjustment of status is going to end in 6 months or 1 year for you. This may last anywhere between 3 years to even 10 years. And you may laugh at me. Why would it last for 10 years? Well, in 2012, though, the priority date was May 10th for EB2. Guess where it is right now, the final action date is. It's in now, it's 2009. So in 9 years, the priority date still did not become current. They are still in adjustment of status. Some of those people are. So if you plan to consider to maintain the non-immigrant status, you have to have the H-1B, maybe 3 times extensions, maybe 4 times extension. You need to have the H-4, and you need to have the stamping every time you go outside the country and come back. And H-4 EAD becomes a problem because typically it takes a long time to get the H-4 EAD. There are a lot of different problems that are associated with maintaining the non-immigrant status. So please be observant on all these things before you make any decision.
Right. That was a lot to take in, Rahul Garu. There's so many permutations and combinations, like you were mentioning, on scenarios of what to do and what not to do. And I hope all of you watching this have had some clarity on how to proceed next. We're going to start our next segment, and we've now officially named it the WWRD. What would Rahul do? Segment and Mata. So on that note, we're going to start taking our callers. So let's go to our first caller. Hello. So area code 205. We're ready for you. Okay, Rahul, while we're waiting on the caller, we have a question. This is from 𝗧𝗟𝗞 𝗦𝗪. He says, if adjustment of status 485 application gets rejected for whatever reason, do we lose the I-140 priority date? What about H-1B? Is H-1B cancelled in case of a 485 rejection?
There are two things. One is rejection is because of picking a wrong box, or maybe they send a wrong check. If that's the case, though, absolutely no problem with the I-140, the priority date, or absolutely no problem with the H-1B. If the 485 is denied for the merits, though, it's definitely a serious matter when the 485 gets. Now, rejection is the mailroom rejects it. Denial means when they take the fees, they look into everything, they issue an RFP, and they deny. If the 485 is denied, it definitely is a big problem, though. Typically, what do we see 485 getting denied for? The underlying I-140 is denied. That's the main reason. If that's not the reason, there must be some criminal convictions that you may have. So that definitely might affect your I-140 and H-1B. So if it's rejection, you do not have to worry. If it's a denial, I would definitely say you should contact a lawyer immediately.
All right, Andy. Thank you so much. On that note, let's go back to our caller, sir. Area code 205, we're ready for you.
Thank you, Andy. Thank you, Nitya Garu, Rahul Garu. Thanks for taking my call.
Sure.
We applied for 485 on October 1st, and they accepted my application. They sent me the receipt notices and the biometrics, everything. And
Sounds
they
good.
rejected my wife's application in December.
Okay.
Hello?
Keep going.
So they rejected my wife's application, but they rejected it pretty late, and we refiled it in December. And it may take some more time to get a receipt number, it seems. And in meantime, my biometrics came in, so they are moving forward with my case. And all my filing date, final action date, everything is current. I'm in AB1A category. December 2019 is a priority date, so everything is going smooth, slowly, but smooth. Everything is going. So if her application is being rejected, which is very low chance, so if her application being rejected again, if this gap extends and if they approve my application, which is 485, finally they give a green card to me, what are the problems that she has to face after that, if her application was not accepted even by then?
Well, you can do one thing. There is something called following to join. It's called I-824, and you can file the adjustment of status again. If by any chance you get the green card approval, though, it seems very unlikely that it's going to be rejected again for her. It seems very unlikely that they're going to give you the green card so soon for you. Okay. And but sometimes they do give green cards to the people who don't want to get the green card, believe me. And that happens so many times. And in your case, you don't want to get the green card. I know that. You don't want to get it right now. I don't, as a lawyer of you, I would say, no, don't give my client the green card. typically what
In
we
my
used
case,
to,
yes, that is true, yeah.
yeah, typically what we used to do in this kind of situation was postpone the biometrics though. That's one thing we used to do very frequently. And they used to accept the postponing of biometrics. The danger point for postponing biometrics right now is that what we're noticing is that when we postpone the biometrics, they're denying the entire 485 application.
No, to minimize this problem, we have an alternative thing is that we have I applied for my H-1B extension since it is ending in a very few months.
Once you get the green card, your H-1B is out.
Yeah, I know, but my wife H1 she also applied for H4 where her biometrics also came in the next month. So her biometrics will be taken as well. So both of our biometrics will be taken in another context.
Well,
so
that's not saving her though. There is something called following to, yeah, because once you get the green card, your H-1B is out, is right?
Yeah.
And your wife, since you're not an H-1B, your wife is not an H-4. So there is something called following to join. If you want to take it as a precautionary step, it's called I-824. You can work on that. You can discuss with your lawyer on that. Okay? Just as a defensive step. But H1 and H4 seems to be working good because you get the green card approved, you get kicked out of H1B automatically.
That's true. Thank you. And the follow-up question is that my I-140 is approved in EB1A category, as I mentioned. So I don't need to submit my supplement J, right? So I didn't actually. So we didn't need to submit a supplement J. And
Wait.
Yeah.
Did you supplement J for your wife or supplement J for you?
For me, neither cases we don't have to submit supplement J because I-140 was approved in EB1A category.
Well, right now you're out of the question right now, though. Is right? Yours is already accepted right now. We're only speaking about your wife. For your wife, you don't have to file a 485J supplement.
Yeah. So now suppose if I get a EAD, can I move to any industry or right now I'm in a non-profit organization like university. So can I move to the industry or technical job changes? So can I do the things that I like?
Did you say that you got EB1A approved or EB1B approved? I was a little bit confused.
EB1A approved. EB1A approved, sir.
And was there a petitioner or is self-petitioning person? You petitioned by yourself?
Yeah, the lawyer, my lawyer petitioned for my.
No, but your employer signed it or you did not sign it?
Employer, they gave a job offer, permanent job offer letter.
Yeah, but they didn't sign the I-140 petition. You can move to a different company. I'm not telling you cannot, but I would be very cautious though. Unlike EB2 and EB3 filing a 485J supplement, for EB1 candidate though, it has to go through very many scrutinies before you move to a different company.
Oh.
Okay.
So that will be little risky.
Right. And as I normally state that for the EB2 and EB3 though, we see very, very rarely any denials. But EB1s though, I would be very careful. Before you even consider any job moving, I would want you to get it evaluated by a lawyer. Okay? Thank you. Thank you very much.
Thank you, sir. Thanks for help. Thanks for your time. Thank you, Andy.
Thanks, Andy. Thank you so much. All right. Let's go to our next caller, Andy. And in the meantime, a question from our viewer, Ishwar. He says, if I use advanced parole at the port of entry, will I be placed into a secondary inspection if I have a short layover in Doha or Abu Dhabi? I'm afraid that I might miss the second because of this secondary inspection. Rahul, 1 second, Andy. So, yeah, we're fine now. Okay, please go ahead, sir.
We have noticed that people who come on advanced parole in some of the port of entries, they are being taken to the soft secondary. We call it a soft secondary. This is called hard secondary and soft secondary. Right. Soft secondary is, you just go to the waiting room, you wait for a certain period of time, and they approve your entry into the United States. That's called soft secondary. The hard secondary is for drug dealers or criminals that are coming into the United States. They'll be placed in a small room that has a restroom. There is a bathroom, and then you can't even flush it. And you have to request officer to flush it, though. That's how, because they're trying to protect certain things. That's called hard secondary, though. I have never seen advanced parole people placed in the hard secondary. I've seen some of them being placed in the soft secondary. When I was the airport director in charge in the IH airport, where I was the immigration lawyers in charge at that point of time, and then they took us a tour on all these things. We asked, why is that, you take the advanced parole people different? Because at the entry where the CBP is, that in some of the airports, though, they cannot process advanced parole. That's the reason they take them to a secondary, and then people get worried about it. Oh, what happened? Am I a criminal or something like that? Don't be worried about it. This is a normal process. It's just a normal thing. Now, having said that, will I miss the flight? I haven't noticed that they will take a long time to in the soft secondary that you will miss a flight, especially in Doha or Abu Dhabi. I have not seen anybody missing the flight because of the advanced parole soft secondary.
Okay. All right. Thanks, Sandy. Let's go to our caller, sir. So area code 917, we're ready for you now. Please press *6 to unmute your line, sir. Sir. Hello.
Rahul garu. Hi, Nitya garu.
Hey.
Chappan, sir. Hi.
Hi, my name is Shiva. Basically, I'm a big fan of Rahul sir. Actually, we took consultation back in October 2020.
Thank you, Shiva.
I have been following Rahul videos since then, actually. Sir, so back in October, you suggest, my H1 got approved in consular processing, and you suggested to go back to India immediately, and now the consulates are opening, so I want to go for visa interview, but my thing is I work for an employer, and there is an implementation partner, and there is an end client. So my client already gave the client letter, actually. February 12th, they gave the client letter. My implementation partner, they are pretty slow. They have a big process and all to give the letter.
I'm not that much worried about, I'm not that much worried about implementation partner giving you the letter. As long as the end client has given the letter, you're in a pretty better shape, though. Implementation partner, it's okay if you don't even have it.
My employer is saying the thing is basically when I went to India, so they completely offshored and have been hired as an offshore freelancer by implementation partner in India. So now I'm coming to on-site, and client is okay for that, and implementation partner didn't give the letter. My employer is like, unless I have an MSA agreement, I'll not give the employer letter.
Oh, your employer is not willing to give it right now.
Because the MSA agreement was not done yet by
I got the point. No, I'm not worried about the implementation partner, but if your employer is telling that he is not going to give an employer letter, that means that you do not have a job offer. Technically, you cannot go for stamping if your employer is not willing to support you right now.
So what kind of documentation is needed from my employer?
He just, an email, go ahead for the interview is enough. Particularly any documentation, right. If he gives a letter, that's fine. If he doesn't give the letter, that's fine too. But if he is telling, don't come right now, I don't have a job for you, you have no eligibility to apply for the H-1B visa.
Can I go with my previous October 2020 letter he gave us? And
no, I am not worried about the letter. I am worried about if the job offer still exists or not. I don't care whether you take the October letter, you take the current letter, or you don't take any letter. But if the employer is telling, I don't have a job, you should not apply for the visa.
Got it, sir. Sir, what's the, if 221G comes and all, what's the period that we can withdraw the 221G or the visa application, visa interview application after 221G has been issued?
Why would we like to withdraw it? I mean, we have to have a reason to withdraw it. Unless we lost the job, we should not withdraw the 221G if there is something that pops up.
Because I want to give an attempt, and if my
you cannot, you should not give an attempt if you don't have a job. That is almost misrepresentation, and then you might be put in a permanent bar coming into the United States. That's all I can tell you, sir. Okay?
Got it.
Thank you.
All right.
Thank you, sir. Thank you for calling.
Have a nice one.
All right, Andy. Thank you. Let's go to our next caller. But in the meantime, I have a question from Sam Reddy. It says, after 180 days of the I-485 receipt, if I lose a job, I can start searching for a job while sitting at home. In the meantime, will USCIS send an RFE or a denial because I do not have a job?
What we typically see in the USCIS is that once in a while they ask employment history of 5 years. What were you doing in the past 5 years? We have to provide the employment history.
Mm-hmm.
That RFE comes almost like, I would say, about 30 to 40% of all the cases that comes in there.
Right.
Sometimes they issue an RFE requesting us, hey, are you still working for the same company? Are you working for any other company? If you're working for any other company, let us, whichever company that you're working, file a 485J supplement.
Mm-hmm.
I would say that if you can find any job in IT industry,
Mm-hmm.
and there are some creative ways, guys. I mean, your wife can form a company and then give a job to you also. I mean, that's legal, perfectly legal.
Right.
If the job exists and you're getting paid and the salary doesn't have to be very high. We have had situations where the spouse has opened up the company and she has, and that company has employed this particular person. We explained to the USCIS that the normal rules of the labor certification don't apply to the 485J supplement, and then we were able to get them cleared up and get the green card. We didn't have any problem. So definitely having a gap is not advisable. Looking into some creative ideas in getting the employment is better. You can always discuss with a lawyer in getting a creative. I'm not telling a fake thing, but companies can start. I mean, companies like Apple started in a garage. Companies like Dell started in a garage. All these things can happen. So you can come up with some creative ideas to get the process done. That's what I would recommend you, rather than having a gap in the employment.
Gotcha. So it sounds like a larger discussion.
Sure.
All right. So moving on to our next caller, Andy. So area code 657. We're ready for you now.
Hello, Rahul Garu.
Yes.
Last week, I gave my biometrics for the 485 application.
Mm-hmm.
And how long it is taking nowadays to get the EAD and AP?
The EAD and AP has nothing to do with biometrics. EAD and AP is taking anywhere between 2 months from the time of filing to 10 months. Now, why is that such a gap? Well, thanks to Trump. That's all I can tell. The new administration is trying to streamline the things to get the things better. But at this point of time, it may take a little bit time for them to streamline the things. The administration definitely has changed, and their attitude in the immigration has changed. So things may move up faster. But at this point of time, I would say it's 2 months to 10 months for you. It has nothing to do with your with your biometrics.
Oh, okay. So once I get the EAD, how my employer can start using that EAD instead of my H-1B?
You don't, if you're working for the same company for the same job, you don't have to use the EAD. If you wish to move from a different company, then you have to use the EAD. If you move from one location to another location, you may want to use the EAD. But if you're working for the same job and everything, you already have your H-1B. Your H-1B has not expired. You don't have to use the EAD. You just keep the EAD in your pocket.
Oh, that's it. Okay. But in case if I have to travel to India, should I inform USCIS, or I can just go there and then while coming back, can I just use AP?
Let me ask you this question. So I'm assuming that you filed an AP also. Just make sure that the EAD card also has an approval of an advance parole. If you don't look at it, then it's going to be completely gone. The other question, next question that I have is, do you have your passport stamped with H-1B or not?
That is expired.
Okay. Yeah.
So I have to go for visa interview again.
That's fine. I mean, you don't have to. If you have an advance parole though, you definitely go to outside the country and you can come back. Do you have to inform the immigration, CBP or Department of State that you are using the advance parole? No, absolutely not required. You just go to India. When you come back on the boarding flights, you just show them the advance parole. When you come to the CBP, hey, how are you coming in? You show them the advance parole card. That's it. You don't have to tell them in advance.
Oh, okay, great. So I missed the point that you were saying something needs to be approved also, like
advance parole. You said your EAD is, you applied for EAD. I'm assuming that you applied for advance parole also. And
right,
you said you're
yeah.
going to travel on EAD. No, you can't travel on EAD. You can only travel on advance parole. The EAD card normally will also have the advance parole, but I want to make sure you have it. Take a look into the EAD card before you embark on any journey.
Oh, okay, got it. Okay, okay. Thank you so much, sir.
Thank you.
All right. Thank you, sir. Thank you for calling.
Thank you.
All right, let's go on to our next caller. And in the meantime, we have a question from Gopi to Canada. And he says, can I publish ebooks on Amazon, like Kindle publishing? Amazon asks for my tax information and SSN. I'm on an H-1B, filed a 485 in October of 2020. Is it safe to do that, or should I wait till I get my green card?
That is a commercial activity. It is a for-profit thing. I don't know if your H-1B authorizes it or the green card looks like it does not. If that's the case, I would wait until you get the green card. Now, after you get an EAD though, if you want to consider doing on a part-time basis other jobs other than the main job, you can definitely consider that at that time after you get the EAD. But however, you would be considered to be married to the adjustment of status. That's fine. You can if you want to. That's so once the EAD comes in, it's up to you if you want to have an additional job like what you're telling. And once you get the green card, obviously, yeah, go ahead. No problem with it. But right now, doing is absolutely big no.
Okay, fair enough. Thank you, Rahul Garu. Okay, let's go on to our next caller, Reddy. So area code 917, we're ready for you now.
Hello.
Hi.
Yes.
Can you hear me?
Yes, sir. Please go ahead.
Hi, Rahul Garu. Thanks for taking my call. So I'm in India right now, and I got 221G asking for client letter. Okay. And my client is not willing to provide me the client letter. So what options do I have?
Let me ask you this other question though. Is this a first time you already have a H-1B here in USA?
Yeah, I got H-1B, but this is my first time stamping. I have F1 visa before.
So you were in USA on H-1B, on a H-1B I-94 for a while, is that right?
Yeah, that's right.
Okay. If you're inclined,
and
sorry, go ahead.
Yeah, sorry. No, go ahead.
Yeah. If your inclined
so
is not... Go ahead, sir.
Go ahead. Sorry, my bad.
We're crossing each other out. If your inclined is not cooperative, though, send an email to the consulate saying that, hey, he's not giving it. You do whatever you want to. And I would write a letter to them that it's not absolutely necessary. The job is with your employer, not with the end client, and then try to explain them justification to see if the consulate approves, which they may not. If that, don't keep on waiting though, because it doesn't make any sense. If your end client is saying, I'm not going to give you the end client letter, what purpose are you going to achieve by waiting? I'm going to take a defense and try to get this one adjudicated, either approved or denied. So send it to them. Say, my end client is not willing to do it. Why do I need to have it? I have my employer letter. I have the job. If they approve it, good. If they don't approve it, well, find another job and come back into the United States on a different H-1B.
Okay. So when I came to India, so my prime vendor got changed to some other Indian company. So that there is no MSA agreement between Indian company and with my employer. So does it cause any issues if I go for visa stamping?
So your Indian employer, that means that you're working there right now. Or
Yeah,
here,
I'm working there right now with the Indian employer.
No, that's fine. If the MSA is not there between the Indian company and your implementation partner, I don't see any problem in getting the stamping done.
No, not between Indian company. It is between prime vendor, Indian prime vendor, and my employer in United States.
But that's not the question they asked in the 221Gs, right?
Yeah, but this is the second question. They are asking for something relationship between my...
Okay. So the consulate is asking the MSA. You said only they are asking end client letter. Now you added the MSA.
Yeah, they are asking both. Show me some relationship between your employer and middle vendor.
Okay. For me, now everything is suspicious right now, whether there's a genuine job opportunity. Did you work for the end client or you did not work for the end client?
I'm working for the end client.
Why is there not an MSA between the implementation partner and your company?
Because when I'm working in onshore, prime vendor is different, and when I moved to offshore, prime vendor got changed to some other company B. So now there is no MSA agreement.
Oh, okay. But there was an MSA agreement before.
Yeah.
Yeah, I would show that MSA agreement that you added before. I would show that MSA agreement and explain them at the end client letter and try your luck. And if that doesn't work out, find a different company, different end client and file H-1B and come back. Don't wait for a long period of time there.
Okay.
Okay. Thank you.
Okay. Thank
Definitely,
you.
I see not cooperating end clients there. That's bad.
Yeah. All the very best, sir.
Okay.
Thank you for calling in. Okay.
Thank you very much.
Move on to our next caller, Andy. And in the meantime, Rahul Garu, there is a question from Shankar Krishnamurthy. He says priority date is 3/11. I-140 was approved on 6/11. Filed EB2 adjustment of status on October 28. My son is 19 and he has an H4. After he gets EAD, if the priority date is not current in the final act date before he turns 21, can he study through his EAD after he turns 21?
Not advisable at all.
Okay.
Because once he turns 21, he may be kicked out because there is a time period of time when the I-140 is pending. That period will be deducted. And after that, after he turns 21, he's not an H4 and that is out, he's out. And then EAD is only valid until the time period the I-140 has been pending. So it may be very less period of time. This kid who is 19 years old should apply for the F1 visa. Should they apply right now or should they wait? That's a decision that he has to make. But under all conditions, I strongly advise that the kid needs to apply for F1 and should not rely on the EAD. That's a major problem a lot of people will face right now. Should not use the EAD. The kids, the teenage kids should not use the EAD.
Okay. Thank you so much, Rahul Garu. Okay, moving on to our next caller, Andy. So area 918, we're ready for you.
Hello, can you hear me now, sir?
We can hear you.
Yes, I can.
Hello?
Yes, we can.
Okay. So my question is regarding H-1B. I mean, I just am changing the project, same employer, but moving to a different client. So, but it's completely remote project. Earlier you said as long as I stay in the same home and same MSA, you might not need to do amendment. Should I or should I not? I mean, my employer says you should be doing. Yeah.
Your employer says what?
My employer says you should be doing an amendment though you are in the same house or same MSA, and it's a completely remote project too. Can I take the chance?
Let me tell you what the law says though. The law says that if there is a change in the employment duties, okay, significant changes in the employment duties, you need to file an amendment. And you're telling that the job is similar. It's not drastically changed, so you don't need an amendment. The law says that if you move from one MSA to another MSA, you need to file an amendment. In this case, you're not moving from one MSA to another MSA. Your MSA, that your home MSA was already covered in your previous H-1B. So technically, you don't need it. But if your company says they want to do it, they have to do it, that's up to them. But this is what the law says.
Okay. So it's okay. I mean, okay. And second question is regarding, I filed the 485 adjustment of status October, just like everybody, EB2 to EB3 downgrade.
Okay.
So I've received all my receipts and waiting for the biometrics and EIDs and APs. So my only thing is, I'm a EVC model. I work for I work as a consultant and employer vendor end client concept. So now I'm trying to convince my company to file for 140 premium processing, just like you're suggesting for everybody. So what is the incentive for the point I'm struggling is, as soon as I ask them, they'll say you're ready to fly, right? So you're ready to go out of our company, right? So what is the incentive they'll have to do a premium processing for me? What do they have? I mean, it is in my interest though, but what is in it for them? How do I approach them?
Let me tell you what is the incentive. If you were my employee, okay, you're asking for the I-140 premium, I know you're going to fly out. I have no doubt. Okay? I have no doubt.
Okay.
I will file the premium processing. I'll let you fly out. I'll let you fly out. You know what will happen to me? You will go out and tell 10 people, this Rahul Reddy is a very nice employer. Go join him.
Okay.
You got it? And that is the incentive. Nothing can beat it. You will go. You will put drums about your employer. My employer is very nice. He filed the premium process. If he doesn't file the premium processing, guess what? You will get the I-140 approval eventually. And then guess what? You got the green card, but you will not like this employer. So if I were you, would I lose 6 months of you? Or would I get 10 more people like you? You will send 10 more people. I know that you will, if I do justice to you. That is the incentive for employers. That should be the incentive.
Okay. So next question regarding the same green card thing. You said that 500,000 people are waiting right now and there are only 250K green cards available for this year. I've been following your videos and know the approximate numbers. So even if a bill passes, even if 100% of green cards are given, even if the spillover happens, just to clear out the line for people who have already applied in October and November itself is going to take 3 to 4 years, right? I mean,
right now, let's not speculate very much. I would say to you right now, prepare yourself to stay here for 5 to 10 years. Prepare yourself to stay 5 to 10 years. Yeah, if something pops up, something comes out, you will be using. But there is nothing you can do right now, is that right? I want you to mentally prepare. Because if you think that I'm going to get the green card in 6 months, guess what? You don't get it. You're going to cry, whine. If you're going to be prepared, okay, it's going to be 5 to 10 years. I will sit on it. I just have to renew the EAD. You'll be in a much better situation. If something pops up, TVASIA will be there. We will come. You will come here. Something a letter need to be written to the congressman or something need to be done. We are going to advise you. For now, I want you to do one thing. Since there is nothing you can do, you're in the best situated than compared to 6 months ago. Of course you are. Just try to think that this is where you're going to stay for the next 5 to 10 years.
Okay. Last question, sir. It's already in the comment, but I'll just take it just one comment ahead. So can we come back to H-1B once we started using the EAD? At any point after 5 years?
It's very tough. It's very tough. You can file the H-1B, then you have to go to outside the country to get the stamping. and then you have to come back into the
Okay.
country. So it's just like what I said is when you flirt with a girl, it's okay to get away from her, all right? But once you get married to the girl, it's not easy to get away.
Okay.
You have to go through a divorce process. That's the reason we have used the word, the TVASIA has invented the word called marrying and flirting.
Married.
Okay? So
Okay.
when you use the EAD, then you are married. To get away from it, you first have to get the H-1B approval, then you have to go to the consulate and get the H-1B approval. It's a long story. It's a very tough story. But it can be done. It can be done.
But it can be done, but the intent will be questioned. Non-immigrant, immigrant conflict could come in.
For H-1B, even if you, in the H-1B, intent is not an issue, sir. For other non-immigrant visas, it may be issue. For H-1 or L-1, intent, immigration intent is not an issue. Thank you very much, sir.
Perfect. Thank you so much. Thank you so much.
Thank you for calling.
Good questions.
And on that note, let's take a quick commercial break and we'll be right back with you guys. Stay tuned. Welcome back, viewers. We have our caller online. Let's not waste any time. Sir, area code 916, we're ready for you now.
Thank you, ma'am. Thank you, Rahul Garu. This question relates to that my employer has applied for my I-485, downgrading my I-140 from EB2 to EB3. And USCIS had received it on October 30th. Still, I haven't got any receipt from them. Should I be worried?
Did you got the check cashed? Did you check on that?
Because it has to go through my, I do not know that whether the check has been encashed or not, because it has to go through my company.
Right now, if I were you, I would not be that much worried about it. But probably in about, because we are still having some checks that are that were filed on 30th are just getting cleared up though. So and the receipt notices have not been received yet for the things that were received on October 30th. So you should be fine at this point of time, sir. It may take about a week's time for you to get the receipt notice.
Okay. And I have another question. After this 485 has applied, there has been something like my company has split into two, like a parent company and a child company, and I am with a parent company, and now they are applying my H-1B again. They applied yesterday actually, so on Friday they applied my H-1B and my wife's H-4. Now, their reapplying an H-1B has an impact on 485 process.
Yeah, it looks to be that the I-140 may have an issue though. So that need to be looked into very closely, why the amendment of the H-1B has been filed. If there is any structural changes in the company though, they are supposed to file one more I-140. That means that your existing I-140 will not be considered to be a valid one. That need to be looked into. I would request that you contact your company's lawyer. They should be able to guide more because they have access to the HR of the company and any documents that are needed. But it is a serious matter. Don't take it lightly.
Yeah, when I contacted them, what they have told me is that they have to file me an I-485J during the time of interview, and that would suffice the need.
I would, as I said, that they have more access. I do not have the access of the structural changes. So you can believe, at this point of time, you should believe in the company's lawyer.
Okay. Thank you so much, sir.
Thank you, sir.
Thank you for calling in. All right, let's move on to our next caller, Andy. In the meantime, we have a question from a rock star. He says it's a critical question. I had a DUI in 2007, which is 13 years ago. This is reduced to a DWAI and all the conditions were met. Will there be any issue with my current 485 application?
Will there be an issue? They will interview you for sure. Okay. You might have already picked up that you have been detained and you have been charged with a crime and you have provided the document of the 485 application. There are some people who are getting waivers for the 485 interview. If you have a DUI, they will interview you for sure. have I seen any 485 cases getting denied because of what Rockstar had?
Mm-hmm.
No, I have not seen any denial of 485. But they will interview, they will quiz him, but I'm pretty sure that he will not get any denial of the 485.
All right, Rockstar, keep on rocking, but not too much. On that note, let's go to our caller, Randy. So area code 615, we're ready for you.
Sir, a very quick question for a friend. Thank you for taking my call.
Sure, sir.
Concurrently filed a new I-140 EB2 to EB3 and I-485 on October 25th, 2020, got received EB3, I-140 approved. And after that, the manager asked to leave the company, look for a new team in the headquarters, which is in a different state, or downgrade to a junior position in the team. So if waiting 180 days was not possible, H-1B expiring July 2021. So they've already asked to H-1B extension. So what are the options? What would Rahul do?
One thing is that this is a serious matter. I would not like to just discuss it on the phone. I would like to look into the issue if downgrading, if you downgrade yourself, if that doesn't cause any problem for your adjustment of status, which most probably looks like it may not because you already downgraded yourself from EB2 to EB3. Instead of moving to the headquarters, if I'm not going to have any problem with the 485 application, I will take a lesser job and stay there for at least 180 days. And after that, I will move out. Either I will move out or I'll move to a headquarters or I will do anything I want to because you already said your I-140 is already approved.
Got it. So there's nothing, any issue with H-1B, right? Extending H-1B right now because H-1B is expiring in 2021, July 2021.
Yeah, but we don't need to worry about that, is right? I mean, why do we need to extend it? Because you have a EAD or you did not have any EAD?
No EAD.
Okay. So you may want to extend it for a period of time until you get the EAD approval. If your EAD approval comes before July, then you don't have to worry about it. But if the EAD doesn't come approval, you file an extension of the normal processing. Once you get the EAD, you can get rid of the H-1B also.
Got it. Thank you so much.
Okay.
Okay, sir. Thank you for calling in. Let's take our next caller, Randy. And in the meantime, we have a question from Rupa Swarupa. She says, in how many days can I withdraw my 221G? Does that cause any negative impact on my visa?
221G, why do you need to withdraw the 221G is my question. I mean, if the job offer is not there, for example, I don't know what the 221G is for. I'm assuming that it must be for the H-1B or L-1. If the job offer doesn't exist, you should withdraw it immediately. If the job offer continues to exist, no reason to withdraw it.
Pratik, sound again.
Sir, can you put yourself on mute? Yeah, thank you.
Yeah, I'm done with the question.
Okay, awesome. So let's go on to our caller, Randy. So area code 858, we're ready for you now. Please press star 6.
Hello, are you able to hear?
Yeah, we can hear you now.
Yeah, I have applied for 485 and I got the receipt. Recently I got it. And my question is, around 2012, one systems administrator SOC code was there. Now the same code is not there. So there is a change in code in 2018. So my present H1 is with LC and all with the old SOC code only. My employer filed the adjustment of status with the older SOC code only, but that is still not valid now. There is a slight number change now. So what will happen to my I-140 downgrade?
Nothing. We'll get approved as usual. No problem with it. We'll not have any problem with the 485 application.
Okay, and one question again. If I-140 is having any issue, there is a small date error done by my lawyer, so I don't know. I did not verify that one. So later when she sent me all the copies, I found like my entry into US date was wrong. So will it impact anything in my I-140 downgrade?
No, sir, it will not. It's just a clerical error. It has no meaning to it. At the most, they may issue an RFE, and I'll be very surprised if they issue an RFE on that too. I don't see that causing any problems whatsoever at all for you.
Mm-hmm. Okay, thanks a lot, and thanks both of you for your help to the community.
Thank you, sir.
Have a good day. Happy Valentine's Day.
Thank you, and wish you the same. All right, let's go on to our next caller, Andy. And in the meantime, we have a question from B Kind. It says, I have an approved 797 for my H-1B extension, but it's not yet stamped. I'm outside the US now for almost 1.5 years. If I want to come back to the US for the same employer but for a different client, what would be the procedure?
You have to file an amendment and get the amendment approved before you go for the stamping, though. Two reasons. If it's 1.5 years, they don't believe that you still have the same job. Second is you don't have the same job. So for all the reasons, you have to file an amendment, get the amendment approved, then go for the stamping.
Okay. Awesome. Thank you, Rahul V. Let's move on to our next caller, Andy. So area code 551, we're ready for you. So area code 551, we're ready for you.
Yeah, hi Nitya. Hi Rahul Garu.
Hi,
This
ma'am.
is Geeta.
Hello.
Geeta.
Yeah, actually, my question is, so for first time H-1B stamping, can we go Mexico? Mexico is allowed for the first time H-1B stamping?
It is allowed right now. You're allowed to go to Mexico for the first time H-1B.
Oh yeah, actually I entered into the US 2014 as a H4. So in 2015 I got the H1. Still I am a H-1B. Before I never attend the H-1B stamping. So is it fine for going right now?
You can go to Mexico. You can go to Mexico for stamping. There are some COVID restrictions you just have to follow. That's it. Everything else is fine.
Oh, okay. Thank you. Thank you, Rahul. This
Thank
is my
you so much
question.
for calling in. All right, let's go on to our next caller, Andy. In the meantime, I have a question from Srinivasan Chandrasekharan. He says, H-1B ended on 30th of September 2020. I-140 was approved and priority date is July 15th, working with the same company in Canada and payroll in Canada. Can I go back to US on an H-1B again with the same company or other company and cap exempt?
Yes, you can, because you were on H-1B before. You have an I-140 approval that has not been withdrawn. I'm guessing after it's been approved for more than 180 days. You definitely can come into United States on a H-1B, absolutely no problem. You are not subject to cap. And if you come with the same company and they have not withdrawn the I-140, even right now, when the priority date becomes current, you can file the adjustment of status. But if you move to a different company filing an H-1B, you come into the United States. If you want to file an adjustment of status, you just have to file a perm and I-140 again. That's all.
Perfect. Awesome. Thank you, Rahul Garu. Let's move on to our next caller. And this area code 201. We're ready for you now. Hello?
Hello.
Yes, sir.
Can you hear me?
Yeah, we can hear you. Go ahead, please.
Yeah. So my priority date is current. Right now I'm living in Delaware. Like I'm planning to move to Pennsylvania. If I make address change, does it affect my green card processing or any delay in my green card processing?
So you have filed your adjustment of status a long time ago, right?
Yeah, currently I'm on EAD. Yeah.
In general, 98% of the time, it doesn't do any good or bad when you change the address. Previously, it was a little bit tough to accommodate the address change. Nowadays, everything is online. You can file something called AR11. You go online, USCIS, AR11. You can file online and it automatically corrects the entire system. So I would say that it does not affect 99% of the time in moving. If you move from one location to another location, it doesn't affect the timing.
Yeah, so the address which I'm moving, right, it's all within the same 5-mile radius where I attended my green card interview. So I don't know, like, yeah, just
Yeah, that's fine. That should not cause any problem.
Okay. Yeah. Thank you.
Right. Thank you, sir. Thank you for calling. Let's take our next caller, Andy. And in the meantime, we have a question from 𝗬𝗪𝗪𝗪. Rahul Garu, this seems like an interesting one. On what grounds can USCIS reject an EB2 to EB3 downgrade for the same employer in same position?
I will tell, I-140 can be denied for, million reasons, but I will tell most common reasons though. First of all, the denial rating, if you're continuously working for the same company, you're being continuously working for the same company and you downgraded though, the percentage of chances, I'm just telling you the percentage of chances of getting the I-140 denial is less than 2% of the time.
Okay.
Now, if you are not working for the company, the reason why you left the company, I mean, you have an I-140 approval, EB2, and you left the company, either you join them back or you're going to join them back in the future. And you filed an I-140 right now on the downgrade, though. There will be a question, the ability to pay. Does the company has ability to pay the salary? Are they paying you the salary? Since they didn't pay the salary while you left the country, you left them, they will have to fill it out with their income tax returns. Do they have enough profit to substantiate the payment, though? What if they have filed downgrade for 20 other people like you? Can they substantiate with the profit? So ability of pay, especially when you are not working for the company, is typically I would say that is the number one reason for the denial. Rest all, I mean, there can be, there's no good reason I could say other than the ability to pay when you file for the I-140 to get denied. Are there any issues with your degree? For example, you have a fake degree, definitely you will be denied. They find it out. I mean, of course, none of our TVASIA clients will do that, but I'm just saying some rare people will get the I-140 denial. Most common reason is ability to pay. Other than that, we don't see much denials in downgrade at all.
Gotcha. All right, thank you, Rahul Garu. And let's go to our next caller, Andy. So area code 949, we're ready for you now.
Hi, Rahul Garu.
Yes.
Step on, sir, we can hear you.
Yeah, I have a couple of questions. One is regarding the adjustment of status. My priority date is August 2013. So in October, I have applied for this adjustment of status, and because of a clerical error, my 485 was rejected. Do I have chance to resubmit or no? Because now they are not accepting the final action dates.
Filing dates, yeah.
Yeah.
I would refile it irrespective of. If they reject it again, let them do it. But what loss are you going to have if you file them again? There have been a lot of these clerical things that are coming up. There's a lot of pressure on the USCIS to accept this application. American Immigration Lawyers Association, which I'm one of the part of the number 2, is also lobbying very much with the USCIS to accept it. There has been an administration change. We all know that instead of zero tolerance policy, that like the way it is, they've been a little bit lenient right now. So we could see that they may accept it. So I would definitely refile the application immediately though.
Okay, thanks. And follow-up question is, so during this process, if I have to change my job, not my job, I mean to say like I need to apply a LCA because of a location change and do a H-1B amendment, would that impact my 485?
It's your application is accepted, your wife's application is accepted, or both applications is not accepted?
Both got rejected.
Okay, you're filing, you're working for a consulting company. You're filing for a consulting company. You're moving from one place to another place, shouldn't affect at all.
Exactly.
However, though, when I'm refiling the application, would I change the address and refile it, or would I not change the address and refile it? I'm not going to answer the question in the live television. The reason is that I don't want to make any changes in the application when I'm resending it, except that one particular clerical thing that we are speaking about, because I don't want to sound as if that I changed the entire thing there, okay? Because address is the main thing. So that's keeping that in mind, though. I would not change the address immediately until they accept it, but technically it should not cause much problem if you ever do that.
Okay. Actually, because of COVID, I'm working from home until this situation closes.
Sure.
So I'll be working from home. In LCA, my home address is one of them.
Good. Sounds good.
If possible, I have another question. Is it okay to ask?
Let's give a chance to more people.
We just have a few more questions to take, but thank you so much, sir, for calling in. Appreciate it. Let's move on to our next caller, Andy. And there's a question from 𝗟𝗩𝗪 𝗪𝗪𝗧𝗛. She says, if one applies for adjustment of status in EB2 and EB3, then are there two H1 EADs?
Two adjustment of status EADs. Yeah, you can get two adjustment of status EADs, yes.
But you can only marry one, right? At any given time.
You can only marry to one, yeah. You can't marry to two at the same time. Yeah, you can use one EAD at a time. You don't have to use two of them.
Got it. All right, thank you, Rahul Garu. Let's go on to our next caller, Andy. So area code 732, we're ready for you now.
Hello, Rahul Garu. Namaste.
Namaste.
Hello, Nitya Garu. Namaste.
Hello, sir.
My question. So I-140 approve అయిందండి prior date 2018. సో ఆ తర్వాత నేను 2 సార్లు ప్రమోట్ అయ్యాను. వాళ్ళు అమెండ్మెంట్ ఫైల్ చేశారు. It's all fine now. So, but the thing is, do I have to apply once again for perm and labor when time comes?
A natural promotion in the similar field, like in the IT or in the IT field, is you don't need to file any amendment for the labor certification and I-140 though. Now you may have to do it on the H-1B, but you don't have to do it if it is a natural promotion. What is a natural promotion? You are working as a software developer, now you become a manager. I mean, that is a natural promotion. Can you become a lawyer from a software developer? That doesn't look to be natural promotion. It's a completely different field. So that point of time, you need to file an amendment. If you just move from software developer to a manager, according to my opinion, it is a natural promotion, does not require any amendment for the labor and I-140.
Yeah, my employer చేయాల్సిన అవసరం ఉంటుంది అని చెప్పారు. ఎందుకంటే there is a substantial change in the
it's up to the employer and an employee to decide. This is my opinion. But if that is his opinion, there is nothing we can do about it. I mean, it is you and the employer who will decide, is it a natural improvement in the position? If you insist upon, no, it is not natural for a software developers to ever become managers in the natural world, yeah, then you have to file an amendment. According to me, it's not, but it's you and your employer who will decide.
Understand. Thank you. Inకొక question, if you allow. Recently, I got a check. So, is there a problem if I cash it? The check is from the Treasury.
This is for the yeah, no problem. No, this is, I'm expecting the income taxes where they have refunded some of the taxes because of the, yeah, no problem, sir. You can take the check and cash it. You're good.
No. I don't think it's for the income taxes. I think it's for the COVID relief. I mean, they didn't attach any letter along with it.
Does it come from the IRS? Where does it come from? Or the state government?
I think it's from the IRS, yeah.
Okay. That is COVID relief. We call the check was being given for the COVID relief. So absolutely no problem. You're affected. Everybody's affected by COVID, and they have given some of the taxes that you paid. They're giving back to you. Absolutely no problem. You take it.
Thank you very much. Thanks for the help, and thanks for the community.
Thank you, sir. Thank you for calling. Let's go on to our next caller, Andy. And in the meantime, we have a question from Akhil Rao. He says file for adjustment of status in 2020 of October. Can I initiate H-1B transfer before the 180 days have passed, but actually join the new employer and file the 485J supplement after 180 days and H1 is approved in premium?
That's fine. They can initiate the process, but I would want the start date of the H-1B to be after 180 days. Okay. I'm also assuming that the underlying I-140 is already approved. I'm assuming. You don't have to.
Yeah, there's no mention of that in this, but yeah. All right, let's go to our caller, Randy. So area code 571, we're ready for you.
Yes, are you able to hear me?
Yes, sir.
Yes.
Yes, thank you, both of you, for helping the community. My question is, we are planning to move to a different address within the same city. And right now, my wife's H4 and H4EAD applications are pending, along with our 485, 131, and 765. I just got the receipts from the MR chart this week from the, for 485, all these applications. Will it create any problem, like if I move now?
No, it does not. You should, as long as you update the AR11, as long as you put out all the file numbers, the I-131, I-765, and your H4EADs, 765, and all those things, you're good. The electronic system is much better right now.
Okay. Actually, my wife's H4EAD is expiring in month of May. We requested by creating 2 service requests, but they denied 2 of them. And I also requested through the House of Representatives, but I didn't get any response. Like, do you recommend anything to get the biometrics done? Because
if you want to, you can join. If you want to, you can join the court litigation. Our office does it every month. And the next court litigation we're going to be doing is in March. If you're interested, you can send an email to our office. But these methods, what you're telling, contacting the congressman, contacting service request, is getting done by everybody, and it's not successful at all. At least 99% of the time, it's not successful. Okay. Thank you very much.
Thank you, sir.
Thank you
for calling. All right, let's go on to next caller, Randy. And in the meantime, we have a question from 𝗓𝗓𝗪. It says, what is the chances of USCIS accepting derivative rejected cases due to simply having an empty box in the 485 form?
I would, if I were to take a judge right now, I would say that there's about 30-35% chance that they will accept this application. There's a lot of pressure from the community to accept these applications. And also, they are fearful that all these people are going to go to court if they are not accepting the application. Especially in the 485, I remember that it's the 4th or 5th page where there is a column that the 3 boxes some of the lawyers did not fill out. That definitely is single most problem of it. And there's a good chance, I would say 30-35% chance they will accept the application. That's my guess right now.
Okay. All right. On that note, let's go to our next caller, Rahul V. Thank you. This is area code 704, Andy. We're ready for you. So area code 704, please press *6 to unmute your line, sir. Okay. Meantime, we have a question from, okay, hold on. Yeah.
Hi, can you hear me now?
Yeah, we can hear you now, sir. Thank you. Go ahead, please.
Yeah, thank you. Thank you, Rahul, sir, for your education for all the immigrant community. I have 2 quick questions. My wife is currently on H4 EAD, and her U.S. employer is ready to file H-1B for her this year. And her passport is actually expiring in August. So will it impact, and we are in the process of renewing her passport, but will it impact the H-1B if she has the validity only for less months?
the passport has to be valid at the time the employer files the H-1B application. We know the process that you have to file the H-1B before July 1st, is right, if you get selected in the lottery. So at the time, if they file before June 30th of 2021, her passport is valid on that day. Does it have to be valid in October 1st? No, it doesn't have to be valid until October 1st. Does it have to be valid until the expiration of the H-1B for which her employer is requesting? No, it's not required. All it requires is the passport has to be valid on the day when the employer is filing the application. Then how come when you look into the internet, you get all these kind of weird messages? There are some issues with the passport expiration date, especially if your wife had a H-1B stamping and she is traveling back to United States. And if the passport, let's say, for example, her H-1, she's already in H-1B, H-1B is expiring in 2021, and the passport is expiring in August of 2021, they may give an I-94 only until August of 2021. But that is not applicable to your wife right now. She is fine, absolutely no problem.
Okay, sure. And one last question, sir. She is, we are thinking the employer might apply her H1 on wage 1, and she is slightly shy of the 60,000. She's currently getting around 58,000. So will it be an issue if they file in wage 1 category?
That is out of the issue right now. We have the Biden administration is not implementing the wage level in selecting in the lottery at this point of time. There may be some small minor hiccups, especially for the specialty occupation, but otherwise the wage level thing that we have discussed on this TVASIA before, which we were worried about, is not applicable in the lottery system this year.
Okay, sure. Thank you so much. And thank
you very much
for what you do. Thank you.
Thank you guys. And folks, we are all out of time today. I know there's so many more questions that I'm seeing and so many more callers waiting, but we are completely out of time. Rahul Garu, thank you so much for your patience, and you've been so great in answering all these questions.
Thank you, Nitya Garu.
Especially on Valentine's Day.
Thank you, Nitya Garu. Thank you, TVASIA, for hosting us. Thank you.
All our viewers, Andy, thank you again. Have a very happy Valentine's Day. We'll see you here next week. Start posting your questions, and Rahul Garu will answer them, and we'll get through as many as we can. And guys, please continue to call us as well. We love to hear from all of you. Okay, so thank you and have a wonderful week. Thank you, Rahul Garu.
Thank you.